Good afternoon, Justice Bloem.
Good afternoon, Chief Justice.
We will start with the interview momentarily. There's just something we need to take care of first, so just give us one moment. Go ahead, Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Judge Bloem.
Good afternoon.
As you're aware, I'm the AFT rep for the GCB on the JSC, and on behalf of AFT, we would just like to withdraw the comments made in response to your application. You would have picked up that it was based on a material error for which AFT unreservedly apologizes, and we want to place on record our unreserved support for your candidacy.
Thank you very much.
Thank
The
you.
apology is accepted, Chief Justice.
Thank you, Chief Justice.
Thank you for being so gracious, Justice Pillay. And you make that statement on behalf of AFT, not as Commissioner Pillay of the JSC.
No, I'm sorry, it's on behalf of AFT, not.
How are you, Justice Bloem?
I'm fine, thank you, under the circumstances.
No, we'll be gentle with you. Don't worry. You have a BA and LLB degrees and a teacher's diploma.
That is correct, Chief Justice.
But you started out as a teacher.
Yes, I actually don't know why I left the profession because I enjoyed the profession.
You were there just for a brief spell. You would have been quite young at the time.
Well, I was in the profession for 1 year.
Oh yeah. And then you did your articles. You embarked on legal education. Then did your articles when you completed your LLB.
That's correct.
All right. Let me just clear this up with you first. Which qualifications did you obtain from Western Cape and which from Rhodes?
I obtained the BA and the teacher's diploma from the University of the Western Cape and the LLB from Rhodes University.
All right. So you did your articles at B. Sandy and Company. Is that firm still in existence?
Sadly, someone else took it over, and in no time, that office had to close.
Oh, that's such a pity. I used to get work from that
Yes.
firm in my past life. All right. Then you went to the Legal Resources Center. Was that in Grahamstown?
That's correct.
All
I
right.
was there for about 9 years.
Yeah. Your application form says clerk/attorney/advocate. What did you do when, and when did you become an advocate?
Well, after completing my articles of clerkship, I brought an application for my admission, and the Law Society said to me, no, you have a diploma course in English and you need a degree course in English. So I had to register to do English in 1990, the year before I was admitted. So my admission was delayed for 1 year.
All right.
And that's why I was a clerk for that year.
Okay. And when were you admitted as an advocate?
That was in 1996.
Okay. Then you joined the bar in 1998.
No, I joined the bar I was a member. I was admitted in 1996, returned to the Legal Resources Center, where I was in-house counsel, but I went on my own in private practice with effect from 1 March 1998.
And you practiced until 2015?
That's correct, Chief Justice.
And joined the bench?
That's correct.
In the Eastern Cape Division
In the
of the High
Eastern
Court.
Cape, where I'm still based.
You've acted at the SCA?
Yes.
Are you there now?
I am now, with effect from the beginning of this term, although the hearings will start only in November.
In November, all right. I just picked up something I'd not seen before with the announcement made by Commissioner Pillay just now. It's made me more attuned to things. I see that you actually chaired out at some stage, and then they turned against you.
Let's spare Commissioner blushes.
Yeah. You have not recorded any reserve judgments, or you don't have any reserve judgments, do you?
Can I respond to that this way? Before I was appointed as a judge, and because I was frustrated when judgments in which I was counsel were delayed, I undertook not to cause litigants to wait for my judgments. I cannot sit here and say to you today that I have not had judgments outstanding for longer than 3 months, but I think there were about 2, if not 3 at most, and those were matters I battled with. But generally, my judgments go out as soon as possible.
Okay.
So at the moment, I do have one outstanding in the Eastern Cape. It's something that I picked up during the last term, but it should be delivered shortly. If not, I will make arrangements with the judge president of the division.
All right. In your 10 years on the bench, you've written judgments. Any reported? And how many would you say you have under your belt, or on estimate?
Well, when I filled in the form, I just made sure that I counted to 10, and I made that 10, and those are the 10 which are reported in the questionnaire.
But you've written many more.
Yes, I did an exercise through Cefli, and I am not in a position to say how many, but they are in excess of 200 to 250.
You've played a significant role in the legal professions, it seems. You chaired, you were a member of NADEL, you chaired AFT in your area. You chaired the Eastern Cape Society of Advocates and the Grahamstown Bar before you joined the bench.
That's correct. How it works in the Eastern Cape is, well, when I talk about the Eastern Cape, I'm talking about Makhanda and Gqeberha, because that's essentially one bar, but 2 different stations. So on the 1 year, someone from Gqeberha would be the chair of the bar, and the following year, someone will be the chair of from Makhanda would be the chair, and this is why you will see I was chair for 2 years.
Yes.
Although during that entire time, I was the chair of the Makhanda station.
And you have other interests. You are involved in the academic community in Makhanda at Rose University. You sit in council, which you've chaired since 2020.
Yeah, it gives me pleasure to give back to that institution where I studied.
And we were both together in the National Bar Examination Board before I left. You still hold your position there?
Yes, I do. And there, hopefully, my teaching skills come to the fore.
Yeah, I'm sure they do. All right, I will leave things there, Justice Bloem, and give my colleagues an opportunity to put questions to you. Any questions? President Molemela?
Good afternoon, Judge Bloem.
Good afternoon, President.
How are you?
I am fine, thank you. I hope you too.
I am fine, thank you very much. You and I started to know one another before we were appointed as judges.
That's correct.
Yes, we were appointed. We both had a first stint at the Free State High Court back in the day.
That is correct. Yes. I remember that very fondly. Thank you.
Yes. And you have now acted at the SCA for several terms. I think in total it's a period of about 9 months, if I'm not mistaken.
Yes, I have acted. I have completed 3 terms. Yes. This is my 4th term.
This is your 4th term. And how did you find it?
Well,
the environment at the SCA, sorry for the interjection.
When I arrived there, I was nervous, but the nerves settled very quickly because, and there's a history to that from what I have learned from other people, what happened in the mid 15, 16, 17, but people also told me things had or were changing. So I was a bit apprehensive, but I arrived there and in no time I felt at ease. Colleagues were very helpful. The environment was one which allowed you to make a contribution, and I have no reason to complain about the situation at the Supreme Court of Appeal.
Yes, the Chief Justice asked you about reserved judgments, and you indicated that you have none except the one at the where you come from, the division where you come from, the Eastern Cape. I can attest to the fact that you are one of the judges who routinely produces their judgments very quickly.
Thank you.
That's a fair assessment.
Well, I worked that out, and I have 2 judgments which were delivered within 1 month. 4 were delivered in 2 months. I have 1 which was delivered in 3 months, and the last one in 4 months. So on average, my judgments go out in 6 weeks.
Yes. And would it also be a fair assessment to describe you as someone with a high work ethic? And I base this on the fact that there was a stage where one of the colleagues fell sick, and he was the scribe, and he could not participate in the panel anymore, and you actually volunteered to be the scribe, which I thought was commendable.
Well, I volunteered because about a few days before that, the matter in which I was going to be scribe collapsed. And so when another colleague fell ill, I then offered to get involved. I did not know that I was going to be the scribe, but I was happy to be scribe in that matter.
Thank you very much, Justice Bloem. Thank you, CJ.
Professor Marumache.
Thank you very much, CJ. Good morning, Judge.
Good morning,
afternoon, actually. I need to ask you about something that I'm not really sure if it's a concern or it is something that is worth debating. Normally, when applications for leave to appeal are brought into the Supreme Court of Appeal, or even special leave to appeal, you'll have 2 judges that are tasked with determining whether or not the matter should go forward or should be refused. And there are times where you find that the 2 judges who are considering the matter may not have came into contact with the subject matter that the application is based. In other words, maybe the matter is dealing with insolvency law, and you might find that the judges might not have had a chance of, either in practice or even in their respective divisions, have not gotten into contact with insolvency law. And you find that the application is refused, and then reconsideration comes and all those kind of things. What I want to understand is, what is the actual criterion that judges generally at that level are applying when they are assessing those applications, so that the parties can be sure that over and above the requirements for leave to appeal, that the matter has been given due regard, so that we can minimize further reconsideration applications, because there are no reasons at the time when the application is made. I think that's just my concern. Yes. I'm not sure if you can contribute to that debate.
Well, two things. The first is, well, maybe we should compare what's happening in the province to what is happening in the SCA. In the province, you get the entire record, evidence and all, sometimes very short, sometimes very bulky. And then you can go through that and decide whether or not there would be prospects of success on appeal. In the case of the SCA, the parties are mostly represented. So the affidavits are drafted such that the parties put forward their best case in the affidavits, founding affidavits, and the following affidavits. And then the judges have to decide also in terms of Section 17 whether there are prospects that an appeal would succeed, or whether there are other compelling reasons for the appeal to, for the applicant to be granted leave to appeal. That I cannot understand on what other basis an applicant's application can be considered.
Okay. Perhaps maybe let me put it another way. What can be done to minimize the amount of reconsideration applications that we are experiencing now, or that court is experiencing now? And obviously, one of the things can say, no, but the attorneys and advocates are just taking chances because there's a procedure is available to them. But we're starting to see that there is actually merit in some of these reconsiderations. Now, that's where my question is. It's like, how should one be confident that these judges are actually seriously engaging with the material before them?
Prof, I can, speaking for myself, these applications or the petitions are taken very seriously because most people know the implications, most judges know the implications of their decisions for the indigent person and for the rich person. Rich person will lose a lot of money. The poor person might have sold his last cow to support the litigation. So every person, in my experience, every person takes any application for leave to appeal in the SCA very seriously. The added aspect I need to highlight is, in the province, you're not told within what time you need to make that decision. However, when you get your petition in the Supreme Court of Appeal, usually lunchtime on a Tuesday, by Thursday it must be out, which means people put aside whatever they do and they concentrate on precisely what I've spoken about. This is an applicant who believes he has a case. Does he have a case? because we're talking about litigation, there will always be a winner and a loser. And the loser would always want to take his case forward. So on the question of reconsideration and how far you take it, you will always have that.
Thank you very much. Thank you, CJ.
Minister?
Thank you very much, CJ. Good afternoon, Judge Bloem.
Good afternoon, Minister.
Let me start, and being from an Eastern Cape province, just want to get your opinion on this issue around the legacy of apartheid system in terms of the structure, where you find that services, or because of that historical past of the legacy, where you find that the organization of the country has been in a particular manner, and the courts have not been spared from this, where you find that where courts are located, or the areas where they are meant to service people in terms of access to justice, are very far from where ordinary South Africans would be within that particular province, especially the vulnerable in terms of their access to justice, because they've got to travel quite a lot, long distances in terms of that. Just to get your feedback as somebody who's been operating in the province, being a judge in that, and also in terms of your profession, having been within that space, what do you think should be done in order for us to reverse the legacy of apartheid and increase access to justice to the people in Eastern Cape?
Minister, things should have changed 29, if not more, years ago. We're still sitting with a situation where if a litigant has a problem and that litigant comes from, let's call it King Williamstown, that litigant drives past Bishop to come to Makanda. Now, it doesn't make sense. That is the situation that obtained before 1994. It still is the position. Now, I need to declare my interest. I live in Grahamstown. I've been schooling in Makanda, etc., etc. And I've been working in that city. And I'm also involved in an institution, Rhodes University. If the decision of the Moseneke, or the recommendation of the Moseneke Commission were to give an expression to, there will be economic consequences, adverse economic consequences for the people of Makanda. I am suggesting that the plight of the people throughout the Eastern Cape be taken care of. We have Mthatha, we have Bishop, we have Makanda, and we have Gqeberha. We also do have East London basically as an operating station. Now, I am sure we can bring about a workable situation so that the issue that you raise, in other words, the person sitting in King Williamstown, which is 10 kilometers from Bishop, can access that court. A person sitting in Pedi, which is in the middle between Makanda and Bishop, maybe closer to Bishop, has a choice to either go to Bishop or to Makanda. So those are the practical things. I do not have answers to your questions. I'm terribly sorry. But these are the things we need. It is, in my view, not good enough to think about Bishop being the seat, Bishop being the capital of the Eastern Cape, and therefore it must be the seat of the court. If Bishop is the seat of the court, and there's a good reason for it, by all means. But we need to think about what it will mean to the people of Makanda and surrounding areas. If it's going to impact adversely on their interests, then I would say we should not go that way. I'm propagating Grahamstown. I've been a victim of prejudice in that community. But I think I must live beyond that. I was not given any work, although I practiced in Grahamstown. I was not given any work by any attorney in town. And today, those very same attorneys would want me to reside or preside in their cases. So there is something in Makanda, and we need to retain the good and do away with the bad in Makanda.
Thank you, Judge Bloem. I know you said you are not having an opinion, but you really outlined very well the issues that needs to be dealt with. Thank you, CJ.
Thank you, Minister. And it's an opinion that's shared very widely by many. Any further questions for Commissioner Ngqoitok?
Judge Bloem, is just to get some clarification about the tenure that's remaining. The AFT's submission says that you will serve up until 2030. That will give you 5 years. The GCB says you will serve for 9 additional years. What is the correct position?
If appointed, I will serve 4 years and a few months. So the 9 years period is incorrect.
Thank you.
Commissioner Muimang?
Thank you, CJ. Good afternoon, Judge Bloem. This side.
Good day, Commissioner.
Thank you. Just one from my side, emanating from the judgment that you highlighted as illustrating your contribution to jurisprudence, the zero tariff innovations. I find it a bit difficult to understand the principles established in this case, which says the Supreme Court of Appeal found that it was just and equitable that the appellant, because it had done work, albeit unlawful and invalid contract, be entitled to payment of any amount that it could establish. Doesn't this advocate for the retention of the proceeds of crime in a situation where the supply chain management process was compromised, right from the specification committee, evaluation committee, adjudication committee, and to the letter of appointment in instances where the appointment of a service provider was compromised? I'm raising this point because SIU, you might have noticed that as part and parcel of curbing corrupt practices, it has embarked on a process of trying to discourage such practices. So this judgment, to my understanding, it goes against what the government is trying to do. Thank you.
Commissioner, with respect, no. What happened in that case, the service provider had nothing to, all the service provider did was to submit its tender. It did not form part of the decision making. It was those involved in the procurement who made wrong decisions. So that decision was set aside. But the ratio of the judgment is that it's not good enough to just set aside a tender. You also, Section 172 of the Constitution says you then need to look at a just and equitable solution to the problem. And that is where we found, up until then, the High Court's decision was correct. But the High Court did not go that one step further And because the service provider had done work, we said it should be paid for the work done. And that's all. It's not they stole money. It's a question of they performed services, albeit in terms of an invalid contract. The fact of the matter is they delivered services and they had to be paid therefore.
Thank you, Judge Bloem. Thank you, CJ.
Commissioner Matolo, followed by Commissioner Steinberg.
Thank you, CJ. Judge Bloem, good day.
Good day, Commissioner.
You spoke about the situation in Makhanda that, we were never briefed by some of the firms. Has the situation changed? And if it has changed, or if it has not changed, what do you think attribute to that? Yes.
Commissioner, 10 years ago when I came here to be, when I was ultimately appointed, that very same question was asked of me. The question is, if there is no will, then we can forget about getting people to brief others. I sit in motion court and I see it would be wrong of me to create the impression that black counsel are not briefed. I see black counsel getting work from banks, but that compared to their white colleagues, you can't compare. But at least it's a beginning. I also shared the problem with the state. When I was the leader of the bar, and without anyone asking me to do so, but because I saw what was happening, and I did not only go to speak on behalf of Black Council in Makhanda, but I also went to speak on behalf of Black Council in Gqeberha. Went to the state attorney and told them, you need to do better. And the state attorney did. But the state attorney, their way of transforming the bar was to send work to white females. So black females and black males did not benefit from that visit to the state attorney. So once again, if there is no will, then things are unlikely to change unless there's, and it might be drastic, for some form of legislation to come, and that will have to be through the state. The state attorney will have to play its role.
Thank you. Just to address, there is legislation now, the Legal Sector Code, which is in place. We hope that it will address that situation. Thanks.
It's one thing, Commissioner, to have legislation. It's another to implement or execute that legislation, and that's not what I see.
Commissioner Steinberg.
Thanks, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
I want you to pick up on the last point of discussion and the Zeal Health Innovations case. I really welcome that judgment. I have again and again had clients wanting to contract with the state who are afraid to do so, because if by no fault of theirs it turns out that the contract was unlawful, they're worried that they would have delivered properly and then not be entitled to remuneration, which is patently unjust. And I think this judgment goes some way to correcting that. The question I have for you is, given how broad the just and equitable discretion is in 172, and the number of appeals one sees to the SCA in particular around the exercise of this discretion, would it be possible and helpful for the appellate courts to start to develop some general principles like this one, which the high courts should then use in situations that arise like this? You have an innocent party who could not be aware of the internal unlawfulness of the contract. Could there not be some form of guidance to lower courts that in those circumstances, the general rule would be that they deserve their compensation? Would it not streamline our courts to have that sort of guidance?
Thank you, Commissioner. I think what you are proposing is correct. However, a case has to be made out for that. In other words, counsel must come to court and say to the court, we are up until here. This is where the law is now. This case cries out for further relief in this direction. And I cannot see why we cannot follow your example, or rather the SCA cannot do what you are suggesting it should.
Thank you.
Commissioner Mangan.
Thank you, Chief Justice. Good afternoon, Justice.
Good afternoon, Commissioners.
I wanted to ask you a question with regard to Section 17.2F that deals with reconsiderations.
Yes.
In the period that you have been at the SCA, did you get a sense that that procedure, that process, is being abused by practitioners? Because my assessment, it's not based on anything, but just out of reading of judgments. The president does give an order of reconsideration, but in the majority of cases, at least those that I've read, the judgments, more often than not, returns verdict of dismissal, suggesting that there is a bit of judicial irritation with that procedure. Is my assessment correct?
Commissioner, I'm sure you would have seen lately there are quite a number of judgments from the SCA dealing with that section. It's something that judges battle with, and speaking for myself, I hope that the latest judgment on it, albeit the court was split 4-1, I hope the majority judgment in that case will be the law, and we will stick to the law. To answer your question, I do not think that, well, let's start with lawyers, attorneys, and advocates. I do not think that they abuse the section. When I was asked earlier, we have a litigant who lost, who believes that his case was not properly dealt with, and he wants to seek further recourse. And the law is there. That remedy is there for that person. And I do not believe that we should close the door for that person. Because if leave is granted, the court will decide whether there are prospects of success, and if so, decide the merits of the case. So that is, I think, what Professor had in mind. Well, if not, then it goes to some way to answering his question.
Thank you, Chief Justice.
Commissioner Gwatsal.
Thank you, Chief Justice. Good afternoon, Judge Bloem.
Good afternoon, Commissioner.
Judge, I'd like to ask whether you have experienced discrimination on the basis of race in your career and perhaps on the bench in your acting stints?
Yes.
And if so, how did those comments by AFT make you feel? How did you respond to it at first?
Well, to answer your last question, I had a big laugh when I was described as a white male. And you will see then it says, that's, I think 6.1, 6.2 says his nomination or his appointment will increase the number of female white judges. So let me just explain to you, if you're asking me, I have shared with you my experience in Makhanda. That is, I was discriminated against because of my color. There's no other explanation therefore. In practice, the legal advisor of the Department of Education once called me and asked me whether I could assist in that matter. In a matter, I said, send the brief, let me have a look at it. And approximately 6 weeks thereafter, he phoned me and he asked, hey, what's happening with the matter? I asked, what matter are you talking about? And that matter was given to a person belonging to a different race. And it hurt. It hurt because that person was my junior by far. And this person, the legal advisor, said to me, I was not Silk at the time. We do not want to appoint Silk, but we want a senior junior. And we thought of you. And I was discriminated against because of it. On the bench, I cannot think of a time that I was discriminated against because of my color. Sorry, I'm not sure. I thought there was another question you asked.
No, it was just if you had experienced a discrimination based on your race, how did the comments make you react or feel?
I had a laugh. I didn't take it. It's my organization, so I knew what's happening there. Thank you.
Sorry, Chief Justice, can I follow up? What do you mean you knew? You don't have to answer.
Thank you.
Justice Bloem, there are no more questions for you.
Chief Justice, thank you very much. Commissioner, thank you very much.
Thank you for making yourself available.
Thank you.
Go well.
Thank you.